delve into the history of the Indian arbitration law, as well as the history of the arbitration law in general. If you remember in the last class, before wrapping up, I mentioned about Lex Mercatoria, that is a mercantile law, how arbitration law was always considered as one of the ways of resolving disputes related to the commerce, related to the merchants and their trade and business, right? So let's go a bit more deeper into that today. And then we come to the 1996 Act, and then we also briefly discuss that what were the changes that were brought in 2015 and what led to those changes. What was the reason? In the first orientation day, I had discussed that how excessive judicial intervention in the arbitration proceedings led to the amendment in 2015, right? But it was not the only amendment that occurred in 2015. There were more interesting features that were added to Arbitration Act in 1996. So today, all of this is going to be a subject area, and with that, we'll wrap up module 1 in today's lecture. I'll be sharing my screen. Any doubts in so far what we discussed in the last 2 lectures? Any doubts?
No, ma'am. None.
Is my screen visible to each one of you?
Yes, yes.
Yes.
All right. All right. So let's discuss that. Let's discuss the general. Let's discuss the Indian law first. Right. Right. So we know that arbitration, we did touch upon it in the previous lecture. Arbitration is something that was a part of the regular village system in the pre-British era, when because we know that British entered in India only in the 17th century. But before that, when we used to settle matters through panchayats, that was the Indian form of arbitration that was already existing in our tradition, right? So, and this is what the panchayat system already had features. Why? Because panchayat had a council of the village leaders, and of course, the senior ones, the ones who are most respected, ones who are considered wise and fair, according to their reputation in the village, right? They would gather around, and generally, the council would comprise of the 5 people, that is how it's panchayat, and then they would hear the dispute from both the sides and accordingly pass a decision then and there, or sometimes in the coming proceedings or in the coming sittings, right? So this is also a form of arbitration. Why? Because this is not panchayat. Of course, now panchayat is recognized by law, but at that time, it was also just like arbitration in the sense that panchayat was also a private court. Panchayat did not represent back then panchayat was not a representative of the state. So it was not a court system, but a private court, and um, that is how it had features of the Indian arbitration process that we have today, or let's say the arbitration process in general. And the decisions, we know that they were binding on the parties, which is important, very important feature that tells us that yes, arbitration tradition did exist before as well. And of course, if everybody would adhere to it, and of course, this was considered as an accepted way of resolving the conflict, and of course, there was no involvement of the formal legal system that existed, and that was generally the appearing before the king and whatever setup that the king had created in his region. But before this existed before, but then the actual codification of the Arbitration Act, we know that it was British who brought codification of law in India, right? So it was only in 1899 that we had a first formal codification of the arbitration law in India, and since it was enacted by by the British um, governing council, so we know that it had a lot of influence of the British legal tradition on the Indian law, in the sense that it provided a framework for resolving disputes outside the court system, right? And it uh, also recognized that disputes can recognize and acknowledge that disputes can also be resolved by a process that need not involve your formal legal traditions, or let's say the formal court and the judicial institutions. And that its application was only limited to presidency towns of Calcutta, Bombay, and Madras. Reason being because these were considered as a trade centers as well. So, and of course, these are all also the places where the courts also existed, the presidential courts existed. So that is why the law was initially applicable, but later on, with the amendment in 1908, that is, which is our next slide, CPC, when they amended finally when they codified civil procedure code in 1908, that's when they extended it to all those parts of India where British exercised its control and administration, right? The Schedule 2, which is now, of course, not part of CPC as such, but it included the application of the arbitration law. And what was the procedure? What was the legal framework that was mentioned in that? It was a very basic structure uh, of conducting arbitration, as in the appointment of the arbitrators. I hope the font size is not very small and it's easily it's legible. The font
Yes,
size,
ma'am.
all right. Thank you. So what all it included? Just the basic features, that is the appointment of the arbitrators. What procedure is just to be followed? That is, once the arbitrator is appointed, we know, just like we have pleadings in court. So here also the requesting party begins first and then so on. So the basic procedure that was written in that. I could not find the Bear Act that had the Schedule 2. I looked online, but otherwise I would have shared it, the Schedule 2, that how it actually looked like. And then, of course, the enforcement of the arbitral awards. So this was for the first time that um, we recognized it and we made it part of the CPC, emphasizing that this procedure can also be opted to resolve the conflict and not just the regular civil suit. Then finally, we had Indian Arbitration Act in 1940, and this was the first time that, if you remember, 1940 was still the time when we were being governed by the crown. However, this was for the first time that we had the word Indian was attached to the arbitration law. Why so? Because um, a lot of matters that involved on only the Indian traders, right? They were also covered under this legislation. And this legislation was all about the disputes that are taking place only within the Indian territory. That is how the Crown gave it a new title, that was Indian Arbitration Act. And it was also a special legislation. That is why they separated it and named it as Indian Arbitration Act. Special legislation specifically devoted to the arbitration process. And it had all details regarding the conduct of the arbitration proceedings. It was similar to what we have in 1996 Act, which is the current legislation. Similar to that. So, conduct of the arbitration proceedings. Please remember that the limitation period, the tenure of the proceedings was something that was not present in this act, and that came only in 2015 amendment to the 1996 Act. That is, there is now a time frame that is given that um, after the arbitrator is appointed, you have to wrap up the proceedings within so and so time. That is, the timeline is now given. However, that is more like indicative in nature, because we know that at times, because of uh, parties and their involvement in the proceedings, in each and every process and each and every decision of the case, the proceedings do take some more time. So that extension time is also given in 2015 amendment. So just the conduct, plain conduct, appointment of arbitrators, and of course the enforcement of arbitral awards. Um, but once again, there was a lot of judicial interference with respect to the arbitrability of a particular matter, because as on today, the question as to um, what sort of dispute will go in for arbitration, that is quite settled. But back then it was not. So there was excessive judicial interference that led to the delays in the arbitration process. However, still the law continued to govern, and the final amendment with respect to the domestic arbitration. Please remember, right now we are discussing only the domestic arbitration. I am not talking about the international commercial arbitration at present, neither the institutional arbitration. We'll be discussing that later on. Now, this and after this, we had 1996 Act, but I'm going to come back to the 1996 Act later. And now let's see that what was a general law with respect to arbitration in the rest of the world. Is it like because it was part of the mercantile law, and it was, we know that trade existed ever since humans have been there on earth, right? So how was it existing? There have been references of arbitration even in the mythology. Like it goes back to the example of the Greek mythology, where we know that a royal shepherd called Mount Ida. Right. The story says that he was asked to arbitrate a dispute among the goddess Juno, Pallas Athene, and Venus. This is just an example, but it also reflects that yes, this concept of our, you know, requesting a private person to actually sit and decide case between two private individuals or two private parties was something that existed even in the ancient mythology of Greece, of the rest of the world, and not just part of the Indian culture. And what were the historical practices that were common during the ancient times? So, with respect to commercial arbitration, we know that it has already been, it was quite known practice in the even in the ancient times. How? Because it was commonly used amongst the desert caravans, especially during the Marco Polo's era, and a lot of traders in Greece and a lot of merchants, they relied upon arbitration, and they deemed it as a practical way to resolve the commercial disputes without resorting to formal systems, because it was much more speedier and much more convenient and much more simpler than the formal process of conflict resolution. So we also know that back then there were not many courts. So the distance and the cost of pursuing a litigation in courts that were far away, so that was also quite too much for parties to bear. So more or less the courts were inaccessible, and they were also slow in uh, proceeding with the case. With respect to civil arbitration, we know that um, in the Greek time, arbitration was considered as a regular practice where the chiefs and the elders in the community held sessions to settle disputes among people. This is similar to the panchayat system that we also had parallelly running here in India. And this form of arbitration was quite informal in the sense because now we know that the arbitration process says that the arbitrator should not be related to either of the parties. That was also the case there, but it was not that the parties had absolute no connection with the persons or the elderlies or the chiefs in the community. Why? Because integrity and unbiased conduct was something that was presumed and not much um, suspected or not much questioned uh, during the arbitration proceedings back then. Of course, the binding nature, again, just like we studied in the panchayat system, this kind of arbitration also had the binding nature. Then we know Athens, it was quite a, we can say, quite a popular city of the Greek culture, right? Um, the king there, they also advanced the practice of arbitration by appointing justice and the judges who travel to the village communities and then they resolve disputes. So here, what was interesting that the recognition from the state, because here the justice itself was appointed by the king. So the state had in a way validated the person and it was a representative of the state, but this justice traveled across different villages and helped them resolve the disputes, right? Um, they, of course, whatever they decided, that had a binding factor on both the parties. And further, it led to the institutionalization of the process eventually, with state involvement in the appointment of the justice, or let's say the arbitrator in simple language. The idea, please remember this because this was quite interesting and this is similar to what we have uh, in US as circuit courts. That is, the courts itself travel to different areas and the litigants don't have to um, travel to the court, travel miles to pursue their litigation and they're basically avoiding unnecessary expense to pursue the litigation. Industrial arbitration, this was again another interesting concept that was existing in the earlier times. And in ancient times, we know that arbitration was also used to resolve the industrial disputes. And back then, we know that industrial revolution happened only in 17th century, and that's when we had the concept of industries and mass production and technology boom. But here, the industrial disputes refer to the master servants and the disputes between the merchants and the laborers, the employment terms, their working conditions and wages. Arbitration applied to such kind of matters. It's very interesting because now we know that um, disputes related to the industry today, they are considered as part of the labor code, and that is how their application is very limited in the Indian law. So that's quite different because now we deem that all the labor matters, because where the interests of the labor is supposed to be taken care, and those are special legislations that are enacted um, to regulate and ensure the safety and the uh, protection to the labor workforce um, in the industrial setup, right? So so arbitration as such today is limited in those matters, but back then there was no such limitation. Arbitration was also open to them. And of course, we know that other regular matters related to the trade and the businesses were also resolved through arbitration. And at the same time, what was the culture that was there um, being followed in US, in the in the American legal system? So arbitration was also used um, to settle industrial disputes. It was back in 1786, almost 10 years after US got independence. They set up the Chamber of Commerce of New York, and it was rendered as the first arbitration tribunal in US, and it dealt with the disputes related to the seamen wages, again related to the trade matters. And that reflected the continuation of the arbitration practices in the new world, because this was for the first time, because the US got independent, and it also had its own constitution, right? After that, so the imperial power and the connection with the imperial power, that was snapped. And now we only now we had what we call today, we were gradually moving towards a progressive and a welfare society, a welfare state. The tradition of arbitration continued to the present date as well. Any questions so far? Because we have briefly touched upon the history and the development of the arbitration law, um, both in the ancient times, in the rest of the world, as well as in India. If there are questions, I'll be happy to take them now. Only then I'll go to the current act, that is 1996 Act. Any questions so far? I'll be sharing this PPT with you after the class. Of course, Akshay will ensure that it's
No.
shared. All right, I'll now go to the legislation 1996. Just allow me a minute. Let me share the legislation with you all. Is this visible?
Yes, ma'am.
Yes, ma'am.
Okay. Okay, thank you. Okay, so now we come to the current law. We know that arbitration is just like we say, dispute is as old as humans are, right? So arbitration was also a process that was not that is not new to our lives. It has already been existing, and it was very much part of our culture. But what is the new law talking about? Um, let's talk about the arrangement of the act and the arrangement of the section. Part 1 deals with arbitration, right? That it covers two processes, arbitration and conciliation. So part 2 talks about the enforcement of the foreign awards. What are these? I'll be discussing that after I um, touch upon what is international commercial arbitration and what is foreign arbitration and foreign awards, where Indian law, or let's say the Arbitration and the Conciliation Act of 1996 is not applicable, but there is a award that is supposed to be executed in India. So what is the procedure then? That all of that is dealt in part 2, and part 3 deals with the conciliation. Part 4 is just the supplementary provisions, not that relevant, although the schedules, we'll be discussing the schedules at length in all other modules, relevant schedules. So part 1 deals with arbitration, and here please remember, it is the arbitration here is not just domestic arbitration, because after 2015 amendment, the court clearly, this legislation has clearly defined what is international commercial arbitration and what are the powers of the of the High Court and the Supreme Court with respect to international commercial arbitration. How much is the interference permitted by the court? Which court would be apt to approach if at all there is any dispute related to the any of the process or any of the stage of the arbitral proceedings? Which court are we supposed to approach? Which would be the appropriate forum? Would it be district court? Would it be high court, or would it be Supreme Court? All of those are now well settled under this new law. What's also interesting, that part 1 applies, once again, part 1 applies to all those arbitrations, whether they are domestic arbitrations, whether they are international commercial arbitrations, to which this law applies. Please remember, and of course, we'll be discussing this at length when we'll be talking about the venue, place, and the seat of the arbitration with the Balco's case at length. Once again, part 1 applies to, I hope you remember this statement of mine. Part 1 of this act applies, is binding, is the operating law for all those proceedings to which Indian law is applicable. To all those arbitration proceedings to which Indian law is not applicable, then part 1 will be inoperative. Please remember this important thumb rule. Remember this. Now, let's
Can you
let's
repeat
yes.
one you said, the thumb rule?
I'm sorry, your voice is not audible. Can you please
No,
repeat?
the one you said about the thumb rule, no?
Yeah.
Okay.
What's it's interesting, and of course, once I start with module 2, that's when I'll explain in detail that you remember discussing the fundamental rule, the cardinal rule with ADR and arbitration process, parties' autonomy. Parties are free to decide which law is going to decide their case, right? Parties' autonomy. But um, part and laws are of two kinds, procedural and substantive. So, in what all circumstances, part 1 will apply to the arbitration proceedings, and in what all circumstances this part will not apply. So, whenever there is a arbitration that's going on between parties, and the parties agree to resolve their matter through Indian law, that's when this act will become operative. This act will be the regulating authority for the purpose of those arbitration proceedings. If two Indian parties decide to resolve their case through, let's say, Singapore law of arbitration, then in that case, this act will not be operative. Or let's say this act would not be applicable. Is this clear?
Yeah.
Yeah, perfect. One significant amendment of 2015, because there was a lot of UN cry with respect to how much an arbitrator can cost. Now, the point is, litigation was time consuming and expensive as well, right? But and we know that arbitration was is considered as the second best alternative, because here also there is an adjudication. In other forms, there is settlement. So there was a lot of dispute that how much an arbitrator can charge. And when this amendment came into effect in 2015, before that the law commission and also delved into this matter, and Indian law took into account the developments that were happening in the developments and the features of the Singapore law, right? Because Singapore is a hub of arbitration for South Asia, right? So we sort of our law, and especially the amendment in 2015, was inspired by them. And then in 2015, through, let me take you to schedules, because this was an important addition. The first convention deals with the foreign arbitral awards. It also existed in the previous act. And the same protocol, fourth schedule, was an important amendment because it laid down it the law indicates that what would be a model fee. But my question is, is it binding? Can parties, if let's say one arbitrator is charging more than the model fee, can parties go for, let's say, the arbitrator demands 70,000, which is more than the model fee, especially if the sum of the dispute, if the subject matter of the dispute is worth 5 lakh rupees at max. The model fee says 45,000, right? Um, Now, since we know that parties' autonomy is at the heart of the arbitration process, so it's not like 70,000 cannot be paid to the arbitrator, and if arbitrator demands and parties pay, so such an arbitral tribunal would lose its mandate. That's not the case, because parties are free to decide. But let's say if there is a dispute, that's when the model fee is going to prevail under the legislation. Only if there is a dispute, that's when the law is going to interfere. Otherwise, let parties decide, and whatever they think is right and whatever they can afford, that would apply, and that would be followed for to the proceedings. Then another significant contribution of 2015, that is the fifth schedule. That is, it clearly lays down, because we know that the independence and impartiality of the arbitrators is very important for both the parties to ensure. Because we know, if you remember, fairness in the process, we discussed that as a cardinal principle in the last session, right? So, extending and ensuring the application of that principle to the proceedings, the fifth schedule lays down the different grounds on which one of the party can challenge the relationship of arbitral tribunal with the parties, and hence can question the independence and the impartiality of the arbitrator. If, please remember my statement from now, if any of the ground that is mentioned here is proved, um, of course, this would be decided by the arbitral tribunal. You will not go to courts for this. Why? Because competence doctrine. Remember that doctrine for now. We'll be discussing that in the second module at length. But the arbitrator himself is going to decide whether parties are able to prove the nexus of tribunal with one of the parties. Now, some of you may say that it is actually against the principle of natural justice because um, it's like nemo judex causa sua, nobody should be a judge in their own case. But that's not the case because you cannot because at times parties, in order to avoid arbitration and they want to settle the matter, what they do is they will go for a lot of challenges that this legislation permits, and they would either go approach to the court and delay the arbitration proceedings or challenge it before the same arbitral tribunal, so that the proceedings are, let's say, stalled for some time. And meanwhile they will initiate, and we and lawyers do that. During my practice I have also seen this happening. It's common, right? Because they want to settle the matter instead of going for arbitration proceedings. Settle it and let's get over with that. Once this is proved, coming back to my statement, once any of the ground is proved, that's when that particular arbitral tribunal, that is the members in that tribunal, single or let's say more than two or whosoever was in question, will lose its mandate. But please remember, the proceedings will not be terminated. What do I mean by arbitral tribunal losing its mandate? It means that whatever that arbitral tribunal is going to held, is going to decide, that will not be a valid. That is, the tribunal loses its authority to proceed and decide the matter. This would be the consequence if any of the ground here mentioned here in fifth schedule would be is established. Similarly, for the seventh schedule as well, once that is established, that's when the tribunal, or let's say one of the members, and depending whosoever is in question, will lose their mandate. Other than this, the 2015 amendment also brought in the time limit for the arbitral award, and this was a significant development, right? What's important, it says in all the matters, the domestic ones which are not international commercial arbitrations, there the tribunal, and by arbitral tribunal I mean whether it is sole arbitrator or it is, because the number of arbitrator always has to be in odd number, just like the bench that we have in court, it has to be in odd number. So either one or three. If parties could not decide on as to the number of arbitrators, then the law deems that in such case only sole arbitrator is going to decide the case. That's the process in brief that I'm explaining here. But by tribunal I mean the arbitrators, either sole or any odd number, any odd figure. They have to decide within 12 months from the date of completion of pleadings under subsection 4 of 23. Now, what is 23? 23 deals with what pleadings, that is, each side will submit their side of the story and will examine the parties and everything. Once that is completed, arbitrator, the tribunal is bound to, it as per the new law, to decide within 12 months. Now, with respect to international commercial arbitration, the proviso says that the tribunal should make an effort to decide it within the 12 months, though it is not a mandate as such with respect to international commercial arbitration. Why? It's practical because at times arranging the witness, if at all, some witness has to testify, or let's say if any document is to be procured from any place that exists outside India, it could be difficult, because we know in international commercial arbitration, one of the parties is not from India, right? We'll discuss that, how a matter is a domestic arbitration and how it is a international commercial arbitration. I'll be explaining that through permutation and combination. So I won't be discussing that at length here. So another significant development was the time limit that was introduced for the first time. And another feature was the fast track arbitration as well. That is, let's um, let's settle the matter as fast as possible. Um, the most important, let me come to the most important amendment to the law in 2015 was with respect to Section 8, which says that in what all matters, or let's say if a contract that has an arbitration clause, how much can courts interfere? Why? Because we know that arbitration, by arbitration agreement, you cannot take away the right of an individual, right of a party to file a civil suit, right? The private law, because arbitration agreement is a private law, that is not going to supersede on the Limitation Act, or what your CPC, the rights to a party under CPC or any substantive law. They cannot prevail over them, right? But here it says that whenever there is and valid arbitration agreement, any matter that has a valid arbitration agreement, then in such case, no matter what any judgment of the Supreme Court, because before this, we had a series of judgments where court had allowed that yes, the courts will interfere even if there is a arbitration agreement that is existing. Why? To check whether the arbitrator is biased or not is related to them. One of the grounds was this, that which allowed the interference of the court before 2015. And the second was to check whether a particular matter was arbitrable or not. That is, whether the arbitrator had the authority to decide a particular nature of the dispute. But considering the competence rule, the fundamental rule, which says, I'm explaining that I have some another 10 minutes in hand. So the competence rule says, I'm mentioning it here. I hope this is visible. Is the color visible?
Yes, yes.
Okay. The competence doctrine says that let the arbitral tribunal decide its own jurisdiction. Why? Because it's competent. It's very logical. An arbitral tribunal, and of course, we know that everything is decided with the consent of the parties in arbitration proceedings. The tribunal does not act on its own as such. In many, let's say, in most of the matters, parties' consent is significant in all the decisions related to the process, right? So, no arbitral tribunal would continue with respect to a particular matter in which it is not competent to decide, because the outcome of such a proceeding would be a void arbitral award and it would be just a waste. And plus, the arbitrator's mandate is of no use in that case, it has no value. So, instead of court deciding what the 2015 Act said, and before that, we had Booz Allen's case, that gave a list of just a suggestive list of disputes that do not fall in arbitration. And after that, in 2015, we had this amendment that says that whenever the only criteria is there should be a valid arbitration agreement as per section 7. There should be a valid arbitration agreement as per section. Then, and no party has applied for a civil suit, and the first statement has been filed in the arbitration proceedings, then come what may, the arbitral proceedings are going to continue and no court is going to interfere. But let's say if one of the parties, before submitting the first statement in the dispute, that is presenting their pleadings, their side of the story before the arbitral tribunal, then in such case, the party, because we know that the right to file a civil suit cannot be curtailed just by a private agreement in such case. So then the court is going to hear the civil suit, and that is going to proceed. And if you continue with the arbitration, we know that that would amount to multiplicity of proceedings. So in such case, the civil suit is going to prevail. So that is why court uh, provided a rider here saying not later than the date of submitting his first statement on the dispute. Then, because if you have not submitted your first statement if you have not submitted your pleadings, then in that case, the proceedings, the arbitral proceedings will not be interfered by the judiciary. This was the most significant development that happened in 2015, because its effect was that it overruled many Supreme Court judgments where the court was divided as to the question of judicial interference that is permissible in the arbitral proceedings. Why? Because what was happening, the effectiveness of the of the arbitration proceedings, that was being defeated. Because if I challenge the proceedings by approaching the court, in a way I'm delaying the process, because then the arbitral proceedings are going to be stayed. So you continue with the suit. The court is, unless and until the court decide that matter, the proceedings will not, arbitration proceedings will not continue. So when there's a stay on the proceedings, that's when you're taking equal amount of time. Plus you are making an expense before the court as well, and you're making an expense before the tribunal as well. So to avoid this, and plus it was also once again amounting to a lot of pendency issue that was already existing in the courts. It almost created a bottleneck situation for many courts in Delhi. That is why that is why the law came up with this amendment, and it's by relying upon this principle, it says that we are going to have least interference. We are going to have least interference in the arbitral proceedings and continue with the matter. Clearly, this part, section 5 as well, it also reiterates what was amended in section 8. It says as long as the act does not permit judicial interference, no judicial authority has the power to interfere in the proceedings. So the law with respect to arbitration proceedings prevails, and that's it. Courts of law, by way of judgments, cannot, by way of invoking legal principles, cannot interfere in the proceedings, and they are going to continue. Again, competence principle. That is, the tribunal is competent enough to, please remember this, tribunal is competent enough to decide its own jurisdiction. They're going to decide just like the courts do, right? Courts also decide their own jurisdiction, whether they have the jurisdiction to entertain a particular suit or not. Similarly, the tribunal is also competent to decide its own jurisdiction. Is this much clear?
Yes.
Any questions? Any questions from what we had discussed today? No questions? Akshay, are you
Yes,
there?
ma'am.
I would request you to please ensure the attendance of the participants, because from next class onwards, we'll be going into the details of the arbitration process. I'll be starting with the legislation,
Okay.
1996 Act, and the important stages of arbitration, appointment of the arbitrator, and so on. The grounds of judicial interference, Section 9. So please ensure that in next lecture there is all participants attended. Only then I'll be proceeding with modules. The modules.
Yes, ma'am. Okay.
Any questions from what we had discussed, what we had studied today? Any questions? Is everything clear?
Yes, but I have a question.